So today 8th class NCERT questions. The first question is about which of the following is true regarding the Indian Constitution. Which of the following is true regarding the Indian Constitution, which is there in the NCERT book. Number 1, the Constitution of India provides for a unitary form of government. No, it doesn't give unitary form of government. Again, it doesn't give federal form of government also. It is what? Quasi-federal. They are very clear that it is quasi-federal. So it is not at all unitary, federal up to some extent. Again, 100% federal means not federal, it is quasi-federal. The first statement is wrong. The President of India has the power to dismiss the state government under certain circumstances. True. See, the President of India has the power to dismiss a state government. The President has the power to dismiss the state government. Answer is wrong. Under certain circumstances, under, which is not extreme. Under circumstances, certain circumstances means 100% correct. So this is second. The right to constitutional remedies is not part of the fundamental right. Whether it is a part of the fundamental right or not part of the fundamental. Article number 32 is a part of the Constitution. The Constitution explicitly defines India as a secular state. See, understand this. This is very important. In the question paper, if they ask Indian Constitution, means updated Constitution. Indian Constitution, if it is present in the Indian Constitution, means that it is updated Constitution. Original Constitution means 1950 Constitution. Did you got it? See, the Constitution explicitly defines India as a secular state. In spite of that, the original Constitution explicitly defines India as a secular state. No. Why? Because secular is added in 1976. It is present implicitly, not explicitly, means that term is not used. If I tell directly, it is called as explicitly. If I tell indirectly, it is called as implicitly. So the term of secular is added to the Constitution in 1976. But here what I asked? Constitution. I told you, if the question is Constitution, if the question is Indian Constitution, means it is updated Constitution, today's Constitution. If the question is original Constitution, then only you have to think about 1950 Constitution. So in updated Constitution, it is secular. By 42nd Constitutional Amendment Act 1976, it's a secular, socialist and integrative. So 2 and 4, this is correct, this is correct. 2 and 4. So what is the takeaway today? The takeaway today is, if the question is Constitution or Indian Constitution, the question is Constitution or Indian Constitution, it is updated Constitution. The question is original Constitution, means you have to think only about 1950 Constitution. Second question, which of the following statements are correct? The right to equality prohibits discrimination on the grounds of religion, race, caste, sex or place of birth. 100% correct. The Constitution of India includes a set of fundamental duties for its citizens. The Constitution of India includes a set of fundamental duties for its citizens. If the question is, the original Constitution of India includes a set of fundamental duties for its citizens, answer is fundamental duties is again added through 42nd Constitutional Amendment Act of 1976. Constitution means updated Constitution. Original Constitution means 1950 Constitution. So this statement is also, the Constitution of India includes a set of fundamental rights. True. The right to freedom of religion does not include the right to propagate one's religion. It is not only about profess, it is also about propagation. So wrong statement. Fundamental rights are absolute and cannot be limited under any circumstances. Fundamental rights are absolute or qualified. According to the circumstances only, the fundamental rights. For example, speech, association, assembly, movement, residence, profession. So for example, profession, it is not freedom. Why? Because prostitution is not allowed. Residence not allowed in Schedule 5 and Schedule 6 area. Movement not allowed in inner line permit areas of Northeast India. Speech, whatever you want, you cannot talk. Association, all associations, government people are not allowed, government employees are not allowed to become the part of political association. Assembly, without weapons you cannot form assembly. So the fundamental rights are not absolute, the fundamental rights are qualified. So the answer is 1 and 2. So one thing, yesterday's class we understood about the extremes. Today's class, one point we got up to know, that is Constitution means updated Constitution. Which of the following statements correctly describes secularism in India? The Indian Constitution allows the state to intervene in religious matters to uphold constitutional values. The Indian Constitution allows the state to intervene in religious matters to uphold constitutional values? 100%. If any religion is motivating to go for untouchability, then obviously the state will involve and restrict the people who are following on the name of religion. So the Indian constitution allows the state to intervene in religious matters to uphold the constitutional values is true. For example, if I am a priest, so priest, I am telling in Hindu social system there is a need for untouchability. Now the state can intervene. The state can intervene and tell that no, what you are doing on the name of religion is wrong. So the state can involve in the religious matters in order to uphold means support, uphold constitutional values. Indian secularism, the state maintains an absolute separation from all the religions. Whether in Indian secularism we are alienated from religion or we are part of religion. We are part of religion. We are not alienated from religion. We involve in religion. Western form of secularism is the state is alienated from religion. In both the cases, understand this, it can be Indian secularism or Western secularism. In both the cases, all the religions are equal before the eyes of state. But however, Indian secularism will involve, Western secularism will not involve. Indian secularism will not alienate, Western secularism will alienate. Religious minorities in India do not have the right to establish and administer educational institutions. Article number 30. Two articles you have to remember. Article 29 and 30, which mainly talks about minorities, religious minorities and linguistic minorities. Article 29 tells that it is a right of the minorities either by language, script or culture to protect and conserve their language, script and culture. Article 29 of the Constitution. Article 30 of the Constitution, either on the name of language or religion, they have the power to establish and administer their own educational institutions. Article 29 and 30. Any question on religious minorities, if it is mains, 29 and 30 you have to remember. Any question on linguistic minorities, you have to remember Article 29, 30, 350A and 350B. What is 350A? Article 350A talks about it is the right of linguistic minorities to have primary education in the medium of instruction of mother tongue. The primary education should be in mother tongue at least up to, it's a constitutional right, it's not a fundamental right, it's a constitutional right. It is present in the constitution but not in fundamental rights. Article 350B tells that there is a need for establishment of officer for linguistic minorities. This officer for linguistic minorities main responsible is grievance redressal of linguistic minority communities. So if it is religious minorities, 2930, if it is linguistic minorities, 2930, 350A and 350B. 350A, at least till primary education, it is the responsibility of the state to provide the medium of instruction in mother tongue. Article 350B, there will be an officer for linguistic minority. So answer is what? Indian state is prohibited from providing financial support to religious institutions. Indian state is prohibited from providing financial support to religious institutions. Yes or no? No, they can give iftar party, Christmas dinner. They are providing Manasarovar project, subsidy for Hajj pilgrimage, who are going for Hajj, Makkah and Medina. Whether the government will provide the subsidy, means they are funding, no? So answer is what? Which of the following are correctly described? Secularism, the Indian constitution allows the state to intervene in religious matters to yes, correct. Secularism, the state maintains an absolute suppression? No. Religious matters do not have the right to establish? No, they have the right. State is prohibited from providing? No. So answer is one only. Which of the following statements is correct in the context of secularism and personal laws in India? One unit is there in 8th NCERT which is called as secularism. But Uniform Civil Code is not discussed in detail, but I brought from secularism. First statement. The Uniform Civil Code as envisaged in the Constitution of India has been implemented. No, under Article 44 of the Constitution, it is present in the Directive Principles of State Policy, but it never got implemented. Has been implemented. Statement is wrong. The Indian secularism permits the state to enact and reform personal laws if they violate constitutional principles. Indian secularism permits the state to enact and reform the personal laws if they violate constitutional principles. For example, triple talaq. Abolition of triple talaq. Who gave the power? The constitution gave. That is the reason they abolished triple talaq. That is the reason they abolished triple talaq. Dowry was being abolished. Who gave the power? Constitution gave the power. So the Indian secularism permits the state to enact and reform personal laws if they violate constitutional principles. True. Example, Triple Talaq Act. When you don't know the theory, when you forgotten concepts, think about examples. When you don't know the theory, when you don't know the concept, if you are thinking that you never studied this, then search for examples. Triple Talaq is a popular example. Then Triple Talaq is a part of personal law, Muslim personal law. Then how they removed and no one questioned. Supreme Court also didn't intervene. Means what? Constitutionally allowed. So constitutional allowing is accepted. Personal laws in India are uniform across all religions? No. The Indian Constitution strictly prohibits the state from any form of intervention in religious personal laws. The Indian Constitution strictly prohibits the state from any form of intervention. No, if that is the case, Triple Talaq would not be removed. Triple Talaq is removed means Constitution is allowing the state to intervene in the personal laws. So this is strictly, Indian Constitution strictly prohibits. No. So the correct is 2 only. Means Indian secularism is allowing the state to intervene in the personal law if it is violating any constitutional values. Next, citizens' participation in Indian democracy. Citizens directly participate in the law-making process, yes or no? Indirectly participate through their representatives. The concept of universal adult franchise includes all citizens above the age of 18. Two things are there. One is called as universal franchise, other is called as suffrage. What is the difference between it? Universal adult franchise means more than 18 years. Universal adult suffrage means men and women. Why that word? Understand this. Universal adult suffrage means, or universal adult franchise means, more than 18 years are allowed to vote. Universal adult suffrage means gender specific. Why? In America till 1929 women were being not given voting rights. In South Africa the voting right of men is 2 and the voting right of women is 1 of value. So universal adult suffrage means irrespective of gender the voting pattern is continuing. So the concept of universal adult franchise includes all citizens above the age of. Public opinion has no influence on the functioning of the parliament. Public opinion will have or not? Public opinion has, see, no is extreme. Some influence will be there. That is the reason they repealed farmers' bill. Example, see, I don't know the theory. Then immediately what I remembered? Farmers' bill was repealed. Means who did agitation? Public. Farmers means public. So public have a role. Public opinion has no influence in the functioning of the parliament. You have to understand that for such a sort of questions, if you don't know the theory, go for example. Farmers' bill was being repealed only because of pressure from public. Citizens can express their views and influence government through elections and public opinion. True. So first statement is wrong. Second statement is correct. Public opinion has no influence on the functioning of, no, they have influence. So 3, 2 and 4. This no means extreme. Public opinion has some influence means correct. Public opinion has full influence, no. Public opinion has no, public opinion has full, public opinion has some. What is the correct answer? Some. Next question. Which of the following statements are correct with respect to judiciary in India? The judiciary in India has the power of judicial review. Yes or no? We borrowed from America. Judicial review we borrowed from America. The Indian judiciary operates under a hierarchical structure with Supreme Court at its apex. Yes. Supreme Court and High Court. Judges in India are elected by the public to ensure democratic representation. No. They are appointed based upon the seniority. The judiciary in India has no role in the enforcement of fundamental right. No. They are the people who review it. So answer is C. Constitution, original constitution or today's constitution talks only about judicial review. It is part of the constitution, but however, by using judicial innovations like public interest litigation, we entered into executive, or we entered into judiciary, entered into executive, or judiciary entered into legislature, which is called as judicial activism. Judicial activism is not present in the original constitution, it is interpreted by the judiciary. So judiciary told, yes, judiciary have the power to enter into the ambit of legislature when the legislature is not working. Are you getting my point? Judiciary interpreted that judiciary, they themselves told, judiciary told that judiciary have the power to enter into legislature. Judiciary told judiciary have the power to enter into executive when executive is not functioning. It's the interpretation of the judiciary, it is not present in the constitution. So what is present in the constitution? Judicial review. For example, the Supreme Court of India had told that crackers should not be played while Diwali festival. Whether it is present in the Constitution of India? No. Then why the Supreme Court of India gave the judgment? They interpreted that when the executive is not working, what the executive should do? Executive should control the pollution. When the executive is not working, then the judiciary is entering into the ambit of executive. So, judicial review is present in the constitution. Judicial activism, judicial overactivism is not present in the constitution. But why it is allowed? Because the judiciary himself told that in the process when the legislature is not functioning, executive is not functioning, we cannot leave the country. So, we are entering into the ambit of 1 and 2. Which of the following statements are correct regarding public interest litigation? PIL. Public interest litigation or PIL is an innovation of P.N. Bhagavati. The former CJI of India, P.N. Bhagavati, came up with a concept called as public interest litigation, whereby a small postcard is enough to take the case. A small postcard is enough to take the petition. That is called as public interest litigation. When the public at the large is getting impacted because of the action of legislature or because of the action of executive, then the postcard is enough to give the justice. That is called as public interest litigation. It is an innovation of Indian judiciary. It is not there in American constitution or American judiciary. It is not there in British judiciary also. It is unique of Indian judiciary. Allows any individual or organization to file a petition in the interest of public. PIL can only be filed in the Supreme Court of India. No. High Court also. The concept of PIL was introduced by the Indian Constitution at its inception. No, it is innovated in 1970s by a CGI called as P.N. Bhagavati. Wrong. PIL has played a significant role in environmental and human rights cases. Yes, mainly they work on human rights issues and environmental issues. So answer is 1 and 4. Yes. There is an advocate called by a name who is called as environmental advocate. Which of the following statements are true regarding marginalization of adivasis? Adivasis or indigenous people or tribal people, the same. Adivasis have been marginalized primarily due to their geographic isolation. No, they are marginalized because of distinct culture, backwardness, geographical isolation, no education, several factors, not just geographical isolation. Adivasis have been marginalized primarily due to their geographical isolation. Okay, we will see. Displacement due to industrial and development projects is a major cause of Adivasi. Major cause. Correct. Adivasis have complete control over forest resources in their areas. Yes or no? The Indian government does not recognize Adivasis as a distinct social group. We recognize, so that is the reason we give ST status. We will see the solution. First one, partially true. Adivasis have been marginalized primarily. That is the reason, partially true. Geographical isolation contributes to marginalization, but is not the primary reason. It is not the sole reason. Partially true. It is not the only reason. It is not partially true. True only. Partially true. But it is not primarily the main. Primarily means the most important reason. Primary means what? The most important reason. So partially displacement due to industrialization is significantly contributed towards, see again, significantly means not fully. Significant English meaning is what? Up to some extent. Significant means not 100%. Significant means up to some extent. Partially. Adivasis often face restriction and loss of control over forest resources. The Indian government recognizes Adivas distinct group often referred to as scheduled tribes. Does not. This is what? Does not. The Indian government does not recognize Adivasis as a distinct group. They recognized. Here it is. So answer is 2 only. Major cause. Adivas complete control over forest resources in the area, no. Primarily, see, the word is very important. Primarily means the sole most important reason. Significant means the most important reason, but not the sole reason. 10th, which of the statements are correct regarding the impact of marginalization on Adivasi community? If you go through the prelims, compulsory minimum 1 question or 2 questions will be on tribals. Marginalization has led to significant cultural and social changes within Adivasi communities. Marginalization has led to significant cultural and social change. Yes. Marpu, social change within Adivasi community. There is a social change because of marginalization. Means when they are not thrown out, they are enjoying. When they are thrown out, they became marginalized. When they became marginalized, there is a change. The loss of traditional lands has had little impact on the economic stability of Adivasi community. See, the loss of traditional lands had little impact or more impact. We will see. Marginalization has not affected the educational opportunities for Adivasi children. Affected. Adivasi community have been active in resisting marginalization and asserting their rights. Adivasi communities have been active in resisting marginalization and asserting their rights. So, one by one we will do. Marginalization has led to significant change in social. The loss of traditional lands has significantly impacted their economic stability. Educational opportunity for Adivasi children are often limited due to marginalization. Marginalization means what? Neglected, poverty, hungry. These are all the reasons. Adivasi community have actively, yes, 100%. So, answer is 1, 4.